Hello, good afternoon all. Thank you for the very kind introduction. So as you've heard, my name is John Dove and I'm a criminal barrister from Charterhouse Chambers up in Liverpool. So today I am going to be talking to you all about the plea mitigation. And if any of you have an interest in crime and you end up doing some form of defence work, this is a piece of advocacy that you will perform very regularly from the outset of your career, both in the Magistrates Court and in the Crown Court. So what I'm going to cover today is I will talk about what the plea mitigation is. I will talk to you about what we should include within a plea mitigation. And then I have a fictional scenario. So I'm going to read out the fictional scenario to you. It might take a few minutes for me to do that. And then we'll have a discussion as a group about what we would want to include within our specific plea mitigation. And then I'm going to finish by delivering a short plea mitigation for that scenario. But just before I jump into that, it was mentioned that I'm also the founder of Speed Mooting. So I thought I'd speak to you just for a minute or two about that. So Speed Mooting as an organisation, we've been going for 12 years. We run lots of events to help aspiring lawyers, both barristers and solicitors. We run lots of advocacy and speed mooting competitions. So we have 4 competitions a year and they're focused solely on your oral advocacy. So you don't need to worry about drafting, research, etc. We include everything for you. Our competitions focus on the advocacy. But alongside that, we have an advocacy club. It meets twice a month and it gives aspiring lawyers and practicing lawyers for that matter, the chance to practice advocacy in a very low pressure environment. So as I say, it meets online twice a month and we cover all forms of advocacy. So civil, crime, family, mooting, and of course, trial advocacy as well. So the problem that I'm going to talk to you about today, this case scenario, is one of the scenarios that we cover at the Advocacy Club. So this is the type of advocacy that you can practice within our Advocacy Club. So firstly, what is a plea mitigation? So within a criminal case, whenever you have a defendant that has either pleaded guilty to an offence or has been convicted after trial, they need to be sentenced. So at their sentencing hearing, the prosecutor will stand up, open the case, read some facts about the case, tell the court where they think it falls on the sentencing guidelines. And then it falls to the advocate that's representing the defendant, whether that's a barrister or a solicitor. It falls to that advocate to present an argument, which is known as a plea mitigation. So what they want to do is they want to seek to persuade the court to essentially give their client the best possible outcome. So whether that's a shorter prison sentence, whether that's avoiding a prison sentence, or whether that's simply obtaining a fine, whatever it might be, they're seeking to obtain the best outcome for their client. So the key things that you would want to include within a plea mitigation would be credit. So if an individual pleads guilty, they get credit, which means a reduction in their sentence. The earlier an individual pleads guilty, the more credit they get. So obviously at the outset, if somebody pleads guilty, they would receive a third off their sentence. They plead guilty on the day of trial, 10%, and anywhere in between, it works on a sliding scale. You'd want to deal with offence-specific mitigation. So you'll talk about the offence itself, talk about why it is that the offence was committed, anything about the offence itself that may be less serious. So dealing with the offence-specific mitigation. You want to cover personal mitigation, so anything that's relevant to the individual themselves. All of this will make a bit more sense in a moment when I give you the case scenario. You need to look at the guidelines. So most criminal offences have guidelines and you might want to talk about where you say this offence falls on the guidelines. And then also tell the court what you're asking for. If you're asking the court for a suspended sentence, tell the court, be very specific about that. If you're asking for only a fine, tell the court. So you need to talk about that. So what I'm going to do at this moment in time, I'll read out what our fictional case scenario is, and then as a group, we'll have a chat about that. So it might take me a few minutes just to read this out to you, but it's helpful just so you know sort of the parameters we're working with and what this case is about. So this case is in Liverpool Magistrates Court. Scouse barrister, thought let's make it a Scouse case. And our defendant is called Peter Magnuson. So this is the case scenario. So at 2 p.m. on Friday, the 11th of October, PC Smith and PC McRae were on patrol in a marked police car on Edge Lane, Liverpool. They had cause to stop a blue Ford Fiesta ST being driven by the defendant. Peter Magnuson was driving the vehicle. The officers spotted the vehicle travelling at what they estimated to be 60 miles an hour in a 30 miles an hour zone. They activated their blue lights and Peter Magnuson promptly brought his vehicle to a stop. Officers spoke to Peter Magnuson and asked for his name. He identified himself as Jack Johnson. Officers performed a PNC check on the vehicle and noted it was registered to Peter Magnuson. They therefore asked Peter Magnuson if the vehicle was stolen, as the vehicle was not registered to Jack Johnson. He promptly informed the officers that he had given false details and that his name was actually Peter. The PNC check revealed to the officers that Peter had recently been disqualified from driving. He was therefore cautioned and arrested. Peter made no reply to caution. He was taken to Copy Lane Police Station, where his detention was authorised. He was interviewed and made a full admission to the offence of driving whilst disqualified. He informed the officers that he lives in Manchester and he was undertaking delivery work for a small delivery company based in Manchester. He had travelled to Liverpool to undertake the delivery. The round trip was 70 miles, 35 each way. He was charged with the offence of driving whilst disqualified and given a date of the 25th of October to attend Liverpool Magistrates Court. Peter attended court on that date and entered a guilty plea to the offence of driving whilst disqualified. The bench of magistrates adjourned the matter so that a pre-sentence report could be obtained from probation. You, or I in this situation, I have been instructed to represent Peter Magnuson at his sentencing hearing and present a plea in mitigation on his behalf. The prosecutor has opened the case, so we can assume our prosecutor's just stood up and presented an opening. So the prosecutor has opened the case for the court and presented the facts as I have stated. The prosecutor has submitted to the court that this offence falls into Category 1 on the sentencing guidelines. The prosecutor says that there is greater culpability because the defendant was driving shortly after a disqualification has been imposed and he was driving for reward. The prosecutor submits that there is greater harm because he drove a significant distance and there is evidence of bad driving, namely the excess speed. So our chap, he was born on the 8th of September 2001 and he has 2 previous convictions, one from 2020 for drink driving and one for 2023 for drink driving. There was a pre-sentence report. I'm not going to read the full pre-sentence report because we'll be here all day, but I'll just read the summary to you just for your purposes. So what probation said within their pre-sentence report was this. They said, Mr. Magnuson appears remorseful for the offence. He is taking real steps to change his behaviour and is trying to improve his life. He recognises that a custodial sentence could be imposed and he would wish to avoid this, as a custodial sentence could prevent him from attending an upcoming course which will give him future prospects. Should the court be willing to consider an alternative to custody, I would recommend a 12-month community order with 120 hours unpaid work. If a custodial sentence is inevitable, there are factors in the case which the court may wish to consider to suspend the sentence. So on the day, we've chatted to Mr. Magnuson and these are the instructions he gives us in conference. This is the last little part of the scenario I need to read out before we discuss this. So we go and chat to him in conference and this is what Peter says to us. He says he's remorseful for committing the offence. He gave the incorrect details to the police because he panicked. He knew that what he did was wrong and this is why he subsequently made a full admission in interview and pleaded guilty. He was working as a delivery driver for a large delivery company prior to his disqualification. He lost his job as a result of the disqualification. He obtained his current delivery job by not disclosing his disqualification to the employer. Since leaving school at the age of 17, the only job he's ever done is delivery driving, and he was unsure how he could make money in the current climate without any other form of work experience. He was trying to make as much money and save it to support himself through his upcoming course. He's an avid gamer. He hopes to start a 12-month computer course that could give him a job in the gaming industry. The course starts next month. He is fearful that a custodial sentence will prevent him from starting his course in the current cycle, and he may not be able to obtain a place on another course in the future. He lives at home with his mum. He regularly attends his elderly grandmother's house to bring items that she might need, as she does not feel comfortable going out in the winter due to the risk of COVID. He can walk to his grandmother's address. His mum can also do this for him, but she works at a 6-night shift pattern in the hospital, so it would be significantly more difficult for her to attend as regularly as he can. He's now sold the car and says he's never going to drive again during the course of the disqualification. He says he's a good person and has never been in trouble, with the exception of his 2 drink drive convictions. He's willing to undertake any form of unpaid work, but doesn't want to go to prison. And he would like any additional disqualification to be as short as possible, because it's going to be beneficial to have a car once he undertakes the course. Now then, so they're the instructions from the defendant. We know the facts of the case. So if we were presenting this plea and mitigation to the court, what would we want to include from this case scenario, from what the defendant has told us? What do we want to include?
One thing that I would ask the defendant is whether he's reformed his drinking.
Mm-hmm.
Because if he had, then we could say that he's reformed his drinking, and therefore those future, the past disqualifications, the risk around them were mitigated. And I think from what you've read, this is grandma's dependency on him.
Mm-hmm.
And we'd have to talk around the fact that he didn't know how to make money. But
Yeah, well, of course.
I've got actually a question. So how would we structure the, would you...
Well, we'll come on to that in just a moment.
Okay.
Yeah.
I was going to say you could frame it as asking them to adopt the recommendation and the fact that you've got a recommendation from the president.
Yeah, absolutely. So I'll move on to a few more in just a moment, just to pause on those few thoughts. So, of course, the drinking. I mean, in this scenario, he's not been charged with drink driving. Again, on this occasion, it's the driving whilst disqualified. So just to take a step back, our chap has been disqualified from driving twice. He's now on a current ban. And the reason he's been charged with driving whilst disqualified is because he's on a 3-year ban and he's driving during the course of that. So it's an offence to drive whilst you are disqualified from driving. So the drinking isn't necessarily an issue for the purposes of this specific offence, but of course it's something that the magistrates may well be concerned by. I should say our extensive pre-sentence report does deal with the drinking element of it, and it's under control now. But I thought for the purposes of this, I'd be here all day. If I read the full pre-sentence report, I'd just give you the sort of executive summary.
I think the most important is that he's remorseful, and it was confirmed by the probation officer and also to the defence.
Well, it shines through, doesn't it? So that's a massively important point. And, you know, for almost every offence that you'll find within the sentencing guidelines, one of the, the mitigating factors that the sentencing guidelines sets out is the individual remorseful for the offence. And it's obviously clear to the probation service. They've put that in their report. It's a good pre-sentence report, and it's something that you can say with some force.
I think the general narrative that I would present is he's been in a bit of trouble previously, but he's reforming himself, he's got a plan,
Yeah.
he sort of has ambition, he seems to be getting things together. Putting him in prison would probably blow that to pieces, and also there's all the risk of reoffending that come out of any.
Yeah, absolutely. That's so important, because one of the points that we're going to be dealing with towards the end of our plea mitigation is, well, if the court feels this is so serious that custodial sentence must be imposed, we need to consider whether or not to suspend that sentence. And there's around 6 factors that the court normally look at when it comes to taking into account whether or not to suspend the sentence. One of those is the prospect of rehabilitation. Now, of course, within the probation report, they're basically saying, yes, this man can be managed in the community. And beyond that, he's got a plan. He's a man with a plan. He knows what he's doing going forwards. He's changing his life. So it shows that he can be rehabilitated. So it's massively important for the court to take that into account.
I think the most important factor that would be focused on in the plea mitigation is the fact that he confessed, right then and there he stated that
Yeah.
he did that it was written at the police station as well. And while all the other arguments are persuasive to the magistrates, this is clear-cut facts that this would reduce the sentence immediately.
Well, absolutely. So it's one of the first things that you get. It's one of the easiest boxes you can tick. So say it at the outset, early guilty plea. So as you say, maximum credit. So he's going to get a 33% reduction on whatever it might be. And then beyond that, it's also evidence of his remorse as well, isn't it? He's made the admissions in interview. And also he's pleaded guilty at the first opportunity in the magistrate's court. Sorry, yeah.
Isn't the elephant in the room the fact that he was doing 60 and a 30? And if he was doing that, even if he had a licence, he'd then be banned. So although you can say he's remorseful, surely one has to find out why he was speeding at such a dangerous speed.
Yeah,
try and explain that to the magistrate.
To a point. So that's one of the factors here. So looking at the sentencing guidelines, so I actually sort of printed a copy. So with the sentencing guidelines for this, there's what you look at are sort of the culpability and the harm. So on the harm element, the fact that he's got, you know, an unacceptable level of driving, it's actually, how do they draft it within the guidelines? It's evidence of bad driving. So that's what puts him into the top bracket. So he's up there anyway, he's in the top bracket. And that's one of the points that the prosecutor makes. He says, well, he's driving twice the speed limit, and that puts him in the top bracket. The police haven't charged him with careless driving or anything like that. Possibly they could have done, but in the circumstances, looking at totality, I think they've said, let's just charge him with the one offence in this. But that puts him in the top bracket anyway. So the prosecutor's made that point. We can't really dispute that. So if you were trying to fight it and say, well, it's not really bad driving, you'd be on a hiding to nothing. So you've got to accept that point. But he's a young lad in a boy racer car. He's been driving fast. That's the point. That's the point that the prosecutor's making. So you know, he wholly accepts that. He holds his hands up from that point of view. And all you can do is you then mitigate from that point of view.
I would try and argue against a custodial sentence because of the fact that he had something to do with his grandmother being ill, and his mum would find it quite difficult to care for.
Yeah. Absolutely. Another factor for the court to take into account when considering whether a sentence should be suspended or not, they need to look at the impact upon others, so immediate family members and things of that nature. So that's certainly an important factor for the court to take into account.
The main issue for me is he said that he's not going to drive again. Well, he has 2 previous arrests for drunk driving.
Mm-hmm.
What is there to guarantee, or who can guarantee that he will stick to his word and that he actually will not drive again?
Well, I mean, I suppose there is no guarantee, but the key thing he's done here is he's sold his car. So in this scenario, he's saying he's sold his car, and that's his way of saying to the court, look, I'm you know, grown up a little bit, I'm taking responsibility, the temptation's gone, I haven't got the car keys there anymore, so I can't drive this vehicle. You know, you can't guarantee anything in life, can you? But at least with this, at least we can make the submission saying, look, he's made a mature decision here, he's sold the car, so the risk of you know, him driving again is significantly reduced. We'll go to the back of the room.
In terms of prospects, I'd focus on the fact he's got a relatively young age, and like definitely like play on the age thing a lot. And then
100%.
in terms of him wanting a shorter disqualification in the future, I'd make a strong argument about the economic dependency he has on driving and the fact that that's his only means of income. And in terms of keeping him out of criminal activity, that's going to be really important.
Yep, absolutely. So once again, for most criminal offences, one of the mitigating factors that's included within the guidelines that you can look at is the age of the defendant. And as a general rule, up until the point that somebody's around 25, you can say that, you know, this is somebody who's a little bit more immature in terms of their years, and that's a point that can be advanced. And then once again, because he's already on a 3-year ban for the second drink drive, because he's committed this offence, they need to tag, you know, some more months on. And that's exactly the point that you're going to make. He's been remorseful. He's making these decisions going forwards. Let's at least give him a chance. So that's the point that you're going to make in terms of trying to reduce the, you know, how much additional time is on the ban.
I think it'd be worth considering what the court is going to be considering in terms of how much risk he poses to the public, because he's re-offended now in the car a few times. So again, what you said about saying about him selling his car, the fact he's looking for a career change as well, because he said the only reason why he was driving is because he didn't think he could go and get work anywhere else. He's trying to now go into gaming. She doesn't have that reliance on a car anymore necessarily.
Yeah.
And also I'd probably take issue with the fact about the aggravating factor of excess driving, because even though the police saw him speeding, there's no numerical evidence to suggest he was speeding. So draw issue with that?
Yeah, I mean, you could do if you wanted to. So, I mean, you wouldn't do it as part of your plea mitigation. So if he wanted to, he might say, yeah, fine, I was driving, but I dispute the fact that I was doing that sort of speed. And then you're in the realms of having a Newton hearing and all the rest of it. The reality is he accepts it all in this situation. He doesn't dispute that he was over the limit. So you've got two officers who are saying, yeah, we saw this guy travelling at around 60 miles an hour. That's the reason that they caused them to stop anyway. And on your client's instructions, he doesn't even dispute that. So if your client's instructions were, well, I wasn't travelling at that speed, that's when you might be thinking about a trial of issue, etc. But he accepts all of that anyway. So it's just about, well, that element is proven. Let's focus on the mitigation element. But no, completely agree regarding the risk. And one of the points you might be making is, well, if the court is thinking in terms of a custodial sentence, if they were to suspend it, this is basically giving him one more chance, and this suspended sentence is going to hang over his head, and this is the deterrent that's always there. He knows that's looming in the background, and it's effectively giving him a reason not to commit any further offences.
During the probation, when the probation officer presents his case, does not he or she also calculates the risk of reoffending? Is that part of?
Yeah, that's always in there. So so they have sort of tools that they go on, and there's various risks for different offences. That was all within the report. And in fact, I should have said this. It basically puts him as a low risk of reoffending anyway, or for serious harm. I just thought, for the purposes of time, I've read the whole pre-sentence report. We'd still be there now. So I just thought I'll read the executive summary. But no, very good points. The risk that somebody poses is covered within.
Overcrowding in prisons.
Yeah, absolutely. It's another point that you can make, and particularly given this guy's history, he's not got any history of sort of serious criminal offences there. It's a point that can be made, so it's certainly something that you can include within your submissions. Maybe take one more, and then I'll probably have to jump onto my plea mitigation soon.
I just had a question. So in these type of cases or in this hearing, can you bring in maybe like a character witness, so maybe the grandmother we were talking about, in order to persuade the magistrate?
So more often than not, when you're presenting a plea mitigation, you will rely upon character references. Not always, but some people tend to bring character references. Could be an employer, could be family friends, could be family itself, etc. Obviously, you check it with the prosecutor. The prosecutor's happy, you hand those into court. And it just gives the court a flavour of what that person's like. So yeah, character references certainly can be relied upon. Time is pressing on, so I'll probably talk about all the things that I've covered here that I would want to include, and then I'll give you an example of the plea in mitigation. So the key things I've noted here you'd want to include: number one, early guilty plea, good way of scoring points at the start. Fact he's remorseful. You give the reason for the offending. So this guy, he's not really got a great deal of qualifications. It's the only thing he knows how to do. He sold the car. He was young and immature at the time. Very limited criminal history, limited qualifications. He's got this good opportunity coming forward. So it's like we've been discussing, he's got this chance to sort of turn his life around. He is sort of a responsible and a dutiful individual. And then lastly, as we've also discussed, the impact that this would have upon others if he were to go to prison. So what I'm going to do now is I will perform this plea mitigation. So I'm going to keep it nice and short. There's obviously all the points that we can include, but I'm going to try and keep this to a nice, simple and short 5-minute plea mitigation. Okay, may it please the court, I appear on behalf of Mr. Magnuson. Mr. Magnuson has entered his guilty plea at the earliest opportunity, and in the circumstances, I invite the court to afford the maximum 1/3 credit. Turning to the offending itself, Mr. Magnuson is remorseful for his offending, as evidenced by this early guilty plea and admission in interview. Mr. Magnuson wholly accepts that he has been driving shortly after the imposition of a ban. Unfortunately for Mr. Magnuson, he is a man of very limited qualifications. He left school at the age of 17 and has only ever undertaken driving jobs. As such, given that he has required an income at this time, he's turned to the only profession he knows how to do. Mr. Magnuson accepts that this was a foolish decision. This decision to drive was, of course, not the only foolish decision that he made that day. He took this further by driving in excess of the speed limit and then, of course, initially providing incorrect details to the police. This is further evidence of his immaturity at that time. I remind the court that at the time of this offending, he was a man of only 22 years of age. I reiterate that Mr. Magnuson is aware of his poor decision-making at this time. Mr. Magnuson has made a mature decision though. He has now sold his car and he assures the court that he will not drive again during the course of this driving ban. Turning to his personal mitigation, Mr. Magnuson lives at home with his mother. He's a man with a limited criminal history. Your worships will note that he has 2 antecedents, both of which relate to driving with excess alcohol. Mr. Magnuson is a man with a potentially bright future ahead of him. He's been offered a place on a computer course that may provide him with a career in the computer games industry. This is a particular passion of his. He is also a responsible individual. He regularly attends his grandmother's home, performs shopping for her, and takes anything that she needs. This is particularly important during the winter months, where she doesn't like to go out and, of course, fears contracting potentially COVID-19. He, of course, does this to assist his mother, who has a busy shift pattern and can't always attend. Turning to the sentencing guidelines, I would agree with my friend's submissions that this falls to be sentenced within Category 1. The starting point is, of course, 12 weeks custody. And whilst I accept that there are aggravating factors in relation to this matter, I would invite your worships to place significant weight on the mitigating factors in this case. When one considers the mitigating factors that I have addressed, I would invite your worships to make a downward adjustment within the bracket and impose a community order. Should your worships not be with me on that point and feel that the custody threshold has been crossed, then I would invite your worships to suspend any sentence. I would remind the court that there is strong personal mitigation. There's a realistic prospect of rehabilitation as evidenced within the pre-sentence report. And of course, were he to go to prison, there would be a significant harmful impact upon his immediate family. Mr. Magnuson has a fantastic opportunity before him with his upcoming course. This may potentially assist him to turn his life around and to turn away from a life of crime. Were he to spend any time in prison, he will miss the course and he may not have the opportunity to complete the course again. Not only that, if he were to go to prison, this would impact upon the care of his grandmother. The pre-sentence report indicates that Mr. Magnuson would be suitable for a suspended sentence and that he can be managed within the community. He's willing and able to comply with any punitive element that the court would impose. Moreover, this suspended sentence would hang over his head as a daily reminder of his offending and act as a further deterrent, unless I can assist any further. So that is just a brief example of how you may go about performing that plea mitigation. So in terms of my structure there, I started by talking about the guilty plea itself. I went through the offence-specific mitigation, so talked about why it was that he committed the offence, talked about why it was that he acted in the way that he did. I then looked at the personal mitigation that we were able to bring out, and then finally looked at the guidelines themselves and what the potential sentence may be. Now, that's not how you would structure every plea mitigation. That's not how every lawyer would structure theirs. If you went into court and you watched 10 pleas in mitigation in a row, you would see 10 different styles. So there's no one size fits all. It's taking your own approach. That's just simply the approach that I've taken on this particular case. Have we got time for any questions at all? Or?
We've got a minute.
A minute? Okay, well, it's probably a good time to wrap up, actually. What I will do is I'll finish by saying this. Thank you very much for listening. I hope that that's been helpful. As I say, I'm from Charterhouse Chambers as a barrister and also Speed Mooting. If ever you do have any questions, always feel free to drop us an email. It's info@speedmooting.com. We have a weekly podcast that we air every single Friday, and we field questions on the podcast. So if you have any questions about life in practice, applications, about advocacy itself, feel free to drop us an email and we can answer your questions on the podcast. So thank you for listening.